India. Distinguished guests, ladies and gentlemen, good evening. Growing up in the mid to late 1960s in a leafy neighborhood of Dhanmandi, my family found itself nestled in a particularly idyllic setting, complemented by neighbors who collectively represented three generations of stalwarts of the legal profession and great judicial minds. To begin with, there was retired district judge, Mr. M.J. Mola, and his wife, who owned a large lakefront house overlooking the Dhanmandi Lake exactly at the point presently occupied by the Dhanmandi Masjid al-Taqwa. Judge Mola was a lifelong dear friend of my maternal grandfather, Justice Muhammad Ibrahim, and therefore, befittingly, he and Begum Mola were saddled with the roles of being our neighborhood Nana and Nani. Our own bungalow stood on Old Road 17, now Road 11A, overlooking the Dhanmandi Women's Sports Complex. Sharing a boundary wall behind us was the house of Justice and Begum A.K. Bakir. Justice Bakir, who retired as one of the more famous judges of the Dhaka High Court, had earlier been the Advocate General from 1954 to 1955. It is, however, to our immediate neighbor next door that we must now turn. This was a large joint family with which an indelible friendship was formed over a period of 20 years by us, so much so that, like Judge Mola's and Justice Barker's family, these friends had become family to us. The undisputed patriarch of this family was Mr. M.H. Khandekar, once Secretary of the High Court Bar 1952 to 1953, and former president of that bar from 1964 to 1965. Mr. Khandekar had, of course, the rare distinction of being the very first Attorney General for Bangladesh from 21st January 1972 to 17th of December 1972. Mr. Khandekar also served out a stint as president of the bar around this time. Mr. and Begum Khandekar to this day remain our Dada and Dadi. That relationship, forged during the turbulent times of the late 1960s and throughout the 1970s, has withstood the test of time and survived my family's physical relocation to Gulshan from Dhanmandi in the late 1980s. The Khandekar household, large as it was, abounded in love and gracious hospitality. It is in that milieu that we grew up knowing one of the Khandekar children, our Katie Chachu, better known as Mr. A.J. Muhammad Ali to the world. Katie Chachu stood out among all his siblings as the quiet one, always by the side of his dear parents, and who never relocated abroad as most or all of his brothers had done. Dada and Dadi's household, in all its daily hustle and bustle, were plagued, however, by one episode of sadness, quietly suffered by all and indeed ourselves as extended family members. It was the loss of a son who drowned in Dhanmandi Lake very early on. With the benefit of hindsight, I now see Katie Chachu, aka Mr. A.J. Muhammad Ali, and his single-minded and unwavering devotion to his dear parents stemming partially from that particular family tragedy. And of course, Mr. A.J. Muhammad Ali followed in his distinguished father's footsteps by studying law. That decision undeniably sealed his destiny as the true legatee of Mr. M.H. Khandakar's outstanding legacy. As we memorialize Mr. A.J. Muhammad Ali today, there has to be the unavoidable references to his leadership role assumed at the bar as president from 2013 to 2014, and his earlier Attorney Generalcy from 30th April 2005 to 24th of January 2007. While all through the 2000s, Mr. A.J. Muhammad Ali and I remained neighbors in Dhanmandi, our interaction was more in the courtroom, as members of the bar and bench, respectively, during this period. Our last engagement, as far as I can recall, in those capacities, was notably to the 2018 case of Begum Khaleda Zia versus the Bangladesh Election Commission. Stemmed from 3 writ petitions, and one of those orders of 11th of December 2018 is reported in 2019 7 CLR 8CD 8. Mr. A.J. Muhammad Ali was the lead counsel for the petitioner, Begum Khaleda Zia, in those 3 related cases in this regard. In a recent international publication, I have particularly highlighted my ruling as the presiding judge in the Khaleda Zia election case as a prime example of how a judgment may reflect the aspirational value of the law. Mr. A.J. Muhammad Ali's arguments in this case convinced me that over and above the factor of judicial independence enabling judges to arrive at coherent, intelligible, and reasoned conclusions as to the scope and nature of the law, judges must allow too for a theoretical or jurisprudential assent to take place in discarding traditional and strictly positivist, modest mode of defining and applying the law. Such theoretical assent, I strongly believe, also has a core moral element to it. And that element, in turn, is essentially constitutional. Bangladesh's constitution, learned members of the bar, like others, places constraints on legislative and executive powers in terms construed to be moral. It is here at this juncture, and in Mr. A.J. Muhammad Ali's memory, I take this opportunity to touch upon a topical issue, that is the debate surrounding an independent secretariat of the Supreme Court. This issue has to be seen in the context of the judiciary's quest for the past 50 years to secure for itself greater parity with its other correlative organs, the executive and the legislature. Never in that half a century, starting from 1975, of constant inter-organ friction has the judiciary been the dominant organ of the state. Never. Though all throughout that period it has served as the fully functional organ, and periodically and strictly the only functioning organ of the state, but never the dominant one. Indeed, it is misconceived to equate the entitlement to institutional independence with a desire to establish judicial hegemony. That is not what the judiciary wishes or seeks. Such an apprehension, as is often expressed nowadays, if there is one, is therefore a misplaced one. Indeed, that dystopian scenario can only play out in the realm of speculation and is not at all borne out by our institutional history of the past 50 years. In this regard, we must take care to distance ourselves from the constitutional misadventures of the recent past, aided by certain rulings of the Supreme Court. They are in a category by themselves and reflect a particular chapter in our institutional history of an unholy alliance struck between an overbearing executive and an enfeebled and pliant judiciary. Those constitutional and judicial overreaches are therefore, ladies and gentlemen, not to be confused with the apprehended scenario of the judiciary somehow going it alone and imposing its constitutional diktat on an unwilling state. That simply has never happened. At the risk of laboring the point of institutional parity, I would like to cite the example of the